associate attorney with Florida Real Estate Law Group, and this is Charles, the lead attorney of the company. Charles, can you tell us about your qualifications?
Absolutely. My name is Charles Malki. I'm the attorney owner of Florida Real Estate Law Group, and I'm also the attorney broker of Florida's Esquire Realty. I've been helping homeowners since the downturn of this market in 2006 and 2007, and I've helped hundreds and hundreds of clients with accomplishing their real estate goals, whether it be doing the deed in lieu of foreclosure, the loan modification, and my favorite is assisting homeowners with their short sales.
Can you explain a little bit about what's contributing to the factors that is resulting in the high foreclosure rate in South Florida right now?
Absolutely. There's a lot of considerations that are contributing in the fact that we're dealing with dropping real estate prices, increasing number of foreclosures, and particularly what we're looking at is the overlending. Lending was way too easy for the last 5 years, particularly through 2004, 5, and 6. And due to the increasing number of mortgages, without doing thorough backgrounds on individuals that were basically doing stated income loans, the fact that they didn't put that much money down on their purchases, and that created the slippery slope that we're looking at today with all these homeowners that are basically turning their backs to the problem. Another important factor is the fact that we've got really high unemployment rates, somewhere at or about 10%, and it's been there for the last couple of years. And the fact that so many of our clients also, resort to our assistance are unemployed, and with that, they have no choice, or they feel like they've got no choice until after they've consulted with our firm. Other factors that contribute to obviously the high foreclosure rates is the construction. There was considerable overdevelopment being supply and demand, and it felt like there was a never-ending limit of buyers that wanted to buy into this beautiful South Florida community. All the way from the Palm Beaches down to Miami, prices were just going up extremely fast, and developers couldn't build fast enough. And right now we have a lot of inventory to clean up as well. So those are just a few of the factors that are contributing to the high foreclosure rates here in South Florida.
Charles, typically, how long does the foreclosure process take between the time that the papers are served until the home is actually sold?
Yeah. That seems to be fluctuating widely depending on who the lenders are and the attorneys that those lenders have hired. Many people are experiencing an easy 2-year period of time where, again, from the time they're served the foreclosure papers until the bank actually forecloses, most people, with them being represented by counsel, are experiencing close to a 2-year period of time before they're actually foreclosed upon. However, if you go unrepresented and you do not defend yourself, do not put an answer with that foreclosure complaint, the process can be sometimes as little as somewhere between 4 to 8 months. So the process can be significantly condensed if you are unrepresented and not defending the foreclosure complaint. And hence the importance, again, of hiring an attorney to at least control the foreclosure timeline.
Now, why would someone want to negotiate a short sale, a deed in lieu of foreclosure, or a mortgage modification, as opposed to just allowing their home to go into foreclosure?
Correct. Depending on the state that you're in, for example, California is a non-recourse state and Florida is a recourse state. This one word alone is a reason why you need to negotiate something with your lender rather than doing nothing. In California, you can do nothing because California is a non-recourse state where the lenders do not go after the homeowners for those deficiencies that result from the foreclosure. Florida, on the contrary, is a recourse state, meaning that the lenders can go after you for the difference. So if your property just goes under foreclosure and you have given up on the process and you do nothing about it, the lenders can now, for example, on a $300,000 mortgage that sells in foreclosure for $100,000, can now go after you for the deficiency, which is the difference of $200,000. So your problems aren't over yet simply by letting your property go into foreclosure. And that is why it's ever more important that the homeowner does something such as the short sale, the loan modification, or a deed in lieu. Those are 3 alternatives to hopefully accomplishing a settlement with your lender that forgives a deficiency so that you're not dealing with these issues that will survive foreclosure.
Does the homeowner need to miss a mortgage payment in order to negotiate a short sale, a loan modification, or deed in lieu as alternatives to foreclosure?
Missing mortgage payments is where there's a lot of also miscommunication and misinformation out there. Whether or not a mortgage has to be missed is really depending on the lender and what the lender's guidelines are at that time. It does change. Sometimes it feels like daily, but they do periodically, I would say from quarter to quarter, change their terms and the policies. In our experience as a law firm defending hundreds of individuals, the loan modifications on average require, I would say again, the majority of them require that you do miss mortgage payments, but the majority of our short sales we've successfully done even for homeowners that for one reason or another need to maintain better credit scores and credit standings at the end of the process, would continue making mortgage payments throughout the process. So it really depends on who the lender is and how we're submitting it to the lender and working with the lender's investors. So it really depends on who we're working with.
Okay, and how do you qualify a short sale client?
Instead of going into all of the other ones like loan modification and deed in lieu, the reason we're just going to answer the short sale is this is where it benefits realtors the most, so that you can hopefully gain the listing and make the commissions. And I just want to pay particular attention to the short sale so that realtors better understand this process. To qualify a short sale client typically requires taking a look at the mortgage amount compared to the value of their property. Going back to the number I used before, if it's a $300,000 mortgage on a property only worth $100,000, we typically suggest and urge the client to consider the short sale as an alternative. The loan modification typically isn't the best solution for this particular client. Again, and this is part of my advice and some of the information that I share with realtors and their clients. The loan modification isn't the best for this particular scenario because more likely than not, again, the lender is going to hold the homeowner responsible for the entire $300,000 deficiency, plus attorney fees, plus interest. So it's going to be larger than $300,000. Even if the payments go down to 50% less, the liability on the homeowner is going to still be just as great, if not greater than, with the loan modification terms that we're seeing with most of these lenders. And that's the primary reason why the client should consider the short sale as an alternative to the loan modification.
Okay, and I think this next question is very important and very pertinent right now. Does a non-lawyer that assists a property owner in engaging in a short sale transaction engage in the unauthorized practice of law?
This issue is ever more important and is becoming the spotlight of the short sales, and a lot of brokerages and a lot of realtors have changed their practices in the last years to incorporate a law firm, and hence the reason we're providing this information today, so you'd seriously consider also using our law firm as a partner in facilitating these transactions here in South Florida. The question again, and I want to reiterate again the importance, is does a non-lawyer that assists a property owner in a short sale engage in the unauthorized practice of law? And assisting a property owner with their short sale is okay, however, negotiating the short sale is not. The rule of the Florida Bar is 10-2.1c of the rules states, non-lawyers are able to engage in limited oral communications to assist a person in the completion of blanks on a legal form approved by the Florida Supreme Court. And for example, one of these forms would be the Florida FAR Bar. Oral communications by non-lawyers are restricted to those communications reasonably necessary to elicit factual information to complete the blanks on a form and to inform the persons on how to file the form. To explain the rule, typically what a realtor is doing and should be doing with a short sale is basically sharing information from the homeowner to the lender and from the lender back to the homeowner. Any of the requirements, any of the necessary docs, they're allowed to basically communicate the documents as they've always done in real estate, but they cannot assist homeowners with preparing the hardship letters, assisting the homeowners with doing the balance sheets, negotiating terms of what the approval letter or the terms of the note and mortgage should be with a loan modification, for example. Those issues are trespassing basically on the rules protecting the legal field and would be violations of the unauthorized practice of law. And these are issues that are now before the Florida bar this year, and will be issues that will be determined no later than 2012. So these are real concerns that are facing realtors and the respective brokers, and how real estate short sales are to be conducted here in South Florida. I would recommend that at a minimum that realtors do engage in hiring an attorney to at least review the short sale approval letter at a minimum, to basically protect the realtor and the brokerages from lenders that have protected their rights to pursue deficiencies even though they've accepted the short sale approval. These are real concerns that we're seeing this year, and these are additional reasons why realtors, homeowners, and brokers should have their attorneys facilitating these transactions with them.
Absolutely. Now, Charles, how can you help realtors in doing more business?
The way we basically help realtors do more business is exactly with what we're doing today. Is basically giving more information and basically facilitating the process. If a homeowner has any questions, has any legal needs, if there's a foreclosure on the property, if there's anything that we can do to basically facilitate the transaction, that's basically where we're here. But furthermore, we're here to protect the brokerages, the realtors, and the homeowners from agreeing to something that they think that they're agreeing to, but they don't actually understand the terms of what they're actually agreeing to. As the owner of Florida Real Estate Law Group, we have our own title company where we can actually produce the necessary settlement statements, supervise the closing, and inform the parties to the transaction every step of the way to closing. And also, as the attorney broker of Florida's Esquire Realty, I'm there to basically help with all of my agents on our staff with doing more business and creating relationships within their communities and all of the surrounding communities, as those HOA boards, maintenance companies, so on and so forth, all needing the assistance of firms such as ours, where we've basically partnered with many buildings and communities on bringing more business to them, closing on short sales, preventing more properties in their communities from going into foreclosure, thereby protecting property values, and bringing more HOA dues back into the communities rather than them just being lost or them just fighting for the minimum statutory allowances than what we can actually produce for them. And those are just more benefits, and I'd be more happy to discuss with the additional advantages on a one-to-one basis if they would call my law firm. And again, my name's Charles Malki, attorney, owner of Florida Real Estate Law Group and Florida's Esquire Realty, and
my name is Helen Hines. I'm an associate attorney with the company.
And we're both proud to be speaking today on behalf of the RAPB, and just want to remind you to tune in next week and every Wednesday at 3 p.m. for additional information. For any further questions, feel free to contact my office at 561-672-7645, or you can gain some more information by visiting our website at www.frelg.com, which is the first initials of Florida Real Estate Law Group. Thank you.